Welcome to the Daily Download. I'm Travis Fain. You probably don't think much about our state Supreme Court, but it thinks about you, your rights, how you're policed, voting rules, and there has been a major shift at North Carolina's highest court. Will Doran is our newest reporter here at WRAL, and he joins us now.
Thanks, Travis. Thanks for having me.
So, Will, you got leaked some notes on major changes that may be coming to the court soon. So there's some intrigue for us to get into, but I want to set the stage first. We elect judges in this state in partisan elections. Before last November, the state Supreme Court had 4 Democrats, 3 Republicans. After those elections, it's 5-2 in favor of Republicans. So now it's a strong Republican majority. What changes have we seen already in the, little more than a month since the new court was seated?
Immediately, the new court came in and made a huge decision, which was that they said, hey, these 2 big voting rights cases that the Democratic majority court heard in late 2022 ruled against the Republican legislature on, you know what, we're going to redo those.
And that's voter ID. So what sort of photo ID we have to show when we vote, and then redistricting, which, people understand gerrymandering. Like, that's how maps get drawn that are so crucial to who holds power in the state legislature and in Congress. They're going to rehear both those cases, right?
Yeah, and it could end up being a swing of 5 or 6 congressional seats towards the Republicans. Right now we have 14 seats in the U.S. House, and it's an even 7-7 split between the parties. We'll see how things go, but it could end up moving towards 10-4, 11-3, something like that.
And deciding that partisan gerrymandering to literally draw a map so that your party gains more power or protects its power could say, hey, that's fine now, which the Democratic court redrew maps. What was it, last year? It all runs together, but in the last year they redrew maps, and that's why we have this split congressional delegation. We could see, as you said, a major swing there. Now, talk a little bit about revisiting precedent and kind of that's unusual. I mean, it rarely happens, especially like 1 month later say, we're doing a do-over.
Yeah, and these were 2 big precedents too. Yeah, and you're right, it rarely happens. We saw in the order that the Supreme Court cited, I think there were a handful of cases that they cited, and it was, over the past 110 years, 115 years. It was a very long period of time with very few cases where the court has ever gone back and reheard a case. And, really not in, major, especially political cases like this where, the big impetus seems to have just been a change in the politics of the court.
Right. In the Democratic court, there was a little gamesmanship before.
Oh, absolutely. Yeah. The Democrats on the court took some flack, and I wrote about this when it was happening too. They sped up a bunch of cases, and they used this kind of weird procedural mover that again has rarely been seen to speed up these cases, because normally a case will take 2-3 years to go through, and they made sure all of these went through in just a matter of months so that they could get heard before the election, because they saw the political winds blowing just the same as everyone else and said, hey, we should probably hedge our bets and get these cases heard before we might be out of office.
Right. So when we point at the Republicans and say, hey, you're blowing past norms by ignoring these precedents and rehearing these cases, well, those precedents probably would not exist if Democrats had not nudged their way past a norm or 2 last year. So our court, there are a lot of concerns that it has become far more political than it needs to be. Now, the document or the notes you came across for this latest story, tell us a little bit about what's next here and how you found out about it.
Sure. So everything we just talked about with the rehearing the cases, that's all about the court, new majority coming in and taking a look at past precedents that have already been set and undoing those. But these documents that I got and these new changes that are being talked about are all about future precedents and giving the court more power over, okay, in the future, what is going to be allowed to be used as legal precedent in North Carolina. And there are 2 big changes. One is that, and this is going to get a little bit into the weeds, but stick with me here. I promise it'll be a good payoff. There's a difference whenever a judge issues a ruling at the appellate level. Some cases are published, some cases are unpublished. And it's a little bit more nuanced than this, but essentially a published case can be cited as precedent in the future, and an unpublished case is you really shouldn't cite that.
So a published one has much more weight to it. Other judges have to look at it and take it into account, whereas an unpublished one, the general public is probably never going to know about it or notice it.
Not only is the general public never going to notice it, but even lawyers who know about it and know that the case exists could even be, banned by court rules from trying to cite it in their arguments if it's a case in their favor.
So this proposed change would basically give the Republicans of the Supreme Court, since they're the majority, more ability to kind of shape the law going forward by shaping the process.
Exactly. Right now, the decision whether or not to publish or unpublish case is up to the judge who writes it. So, at the Court of Appeals, which is the step before the Supreme Court, there's 15 judges there. They hear hundreds, if not maybe even thousands of cases a year, way more than the Supreme Court could ever possibly hear just because they have way more judges at the Court of Appeals. But this change would give the Supreme Court the power to, kind of look back over what the Court of Appeals is doing and say, hey, that case that y'all published, we don't really actually think that was good law. And so we are going to just decide ourselves to unpublish it, even though we haven't heard the case. We haven't, gotten
let's not pay
lawyers.
attention to that, but not through the process where everybody gets to make their argument. We're just not going to pay attention to that. And the other change is kind of along the same lines, because it also involves the Court of Appeals, which right now, if a panel of 3 judges on the Court of Appeals decides a case 2-1, it automatically appeals to the state Supreme Court. What would the change be here there?
So this would get rid of that rule. And this has been how things have worked for years in North Carolina. The logic is, okay, we have these 3 judge panels at the Court of Appeals, and, if 2 of them think it should work one way, 1 of them thinks that the law should work the other way, there's a disagreement on what the law actually says, then yeah, that's something that the Supreme Court should check out and, be the final arbiter on. This would get rid of that automatic right of appeal. And what we've heard from Democrats is that, this is just a way of kind of just further dominating the Democrats who are left on the Court of Appeals.
It's about power.
Right. And saying your dissents aren't going to matter. We don't want to pay attention to you. That's what I heard from Democratic State Representative Marcia Maury from Durham. She's one of the handful of plugged-in people who have heard about these changes. Rumors are starting to trickle down in the legal community, and she was just furious about it. But on the other hand,
and she's a former judge.
She's a former judge herself, too.
And not a reactionary. I mean, that's someone that when she speaks at the state legislature, people tend to pay attention.
Yes. Yeah. She's often measured in what she says, so when she goes off, people do pay attention. But on the other hand, I talked to Bob Edmonds, a Republican former judge of both the Supreme Court and the Court of Appeals. And, he said, well, there's pros and cons to this. I don't really see it as a political thing. I just see it as more of an administrative thing. It could stop if you potentially had a, Court of Appeals judge who was abusing their power and just dissenting on every single case that ever came across, their desk just so
it would automatically be reheard by the Supreme Court.
Right. No, he said that there's no indication that's actually happening right now, but, it's a guard against stopping that from the future. And he noted that, the U.S. Supreme Court operates that same way. If you get, a dissent in federal appeals court, you don't automatically get to go before SCOTUS and argue your case. The judges get to decide which cases they're going to hear. So this rule would, move North Carolina more in line with how the federal courts handle things.
All right, we're going to take a quick break here, and then we're going to talk a little bit about secrets and how they come out included in this case. Stick with us. All right, welcome back to the Daily Download. We're talking State Supreme Court with Will Doran here at WRAL. So you got leaked some documents, some notes on this. Tell us a little bit about that. Tell us who all knew that this major change, these 2 major potential changes, were percolating, and who didn't know.
A lot of people didn't know, until they read my article, at least. But this is something that really started coming out in early January. There was a meeting of the State Bar Association's Board of Governors. And for people who aren't lawyers, the Bar Association is the main legal group. If lawyers are behaving badly, the bar is in charge of, disciplining them and, but it's also in charge of, hosting committees that talk about rules like this and, really kind of facilitating a debate between lawyers and judges to talk about, okay, what's working in the state, what isn't working, how and why can we address it? It's really the forum for these things. So at that meeting, Supreme Court Justice Anita Earls, who is one of only 2 Democrats left on the Supreme Court, according to these notes that I received, spoke up and said, hey, the Supreme Court is working on these 2 major rules changes and they're not telling anyone, but I think it should, be known. She, again, according to the notes, I called her up to see if she would like to do an interview.
She said no, but she confirmed that the notes were accurate. So, I mean, this is all pretty well nailed down. And we talk about who knew, who didn't know. You called Donna Stroud, who is the chief judge of the Court of Appeals. So the chief judge of the court that this would immediately impact, and a Republican. And what she told you, I believe, was that she did not know enough about it to comment, right?
That is what she told me. I asked a couple follow-up questions. Didn't get anything to that.
To be fair, Judge is not big on giving interviews to reporters. Let's talk a little bit about how the court sits and some potential. I don't even feel comfortable using the word potential. So some seemingly clear conflicts of interest that we have on our state Supreme Court because it is an elected body. 39 states use elections to fill at least some of their court seats, by the way. So that's common. Only 11 states, including North Carolina, use party labels in trial courts. And only 8 states use partisan elections to pick the state Supreme Court. So we're one of only 8 states that thinks this is the way to do it. Let's make sure there's an R or a D next to everybody's name who's running for judge. We've got Earls. You mentioned Anita Earls, former civil rights attorney now on the bench. She used to argue some of the same voting rights cases in front of the Supreme Court she now sits on and hearing the same and very similar cases.
Yeah, she made her name in gerrymandering cases.
Right.
Yeah.
Right. Paul Newby, he is a former U.S. assistant U.S. attorney, and he's been on the state Supreme Court since 2004. He's the chief judge now, but he's also a Republican operator. In 2019, I wrote a story where at a campaign event, at a fundraiser, he compared his 6 Democratic colleagues to then freshman Congresswoman Alexandria Ocasio-Cortez, AOC, kind of boogeyman of the right, a Democrat from New York in Congress. And he said he lost sleep at night over the judicial activism he feared from his colleagues. Really unusual for a Supreme Court justice to be dissing all at that point, because it was 6-1 Democrats at that point, all of his colleagues on the bench.
Yeah, no, you certainly do not see that a lot. But you know what people say, elections have consequences, and Republicans swept the judicial elections in 2020. They swept them in 2022, and they now control the Supreme Court and have a healthy majority of the Court of Appeals as well. Yeah,
that's right. I mean, to the extent people are thinking about these things when they go to vote in Supreme Court elections, they have clearly in North Carolina said we want a Republican state Supreme Court. Tamara Berenger, another Supreme Court justice, she's a former state senator. So she has supported and voted on some of the laws that she is now reviewing. And then the best one, Phil Berger Jr., as the junior may tip you off, he is literally the son of Phil Berger Sr., probably the most powerful Republican in the North Carolina General Assembly, and frequently a named defendant in voting rights and other cases. So that gives people an idea of kind of, look, we don't put our judges and justices in a box and send them to their house to do nothing when they're not sitting on the bench. They're politicians in a lot of ways.
Yeah, well, and, part of it, and this is a complaint that we've heard from lots of particularly Democrats as they've been losing these elections, is that, we're doing the elections all wrong. And we need to go back to nonpartisan elections. And we need to, cap outside spending on these judicial elections. Because, you see
millions,
tens of millions of dollars being spent, and lots of it from, just DC-based political groups that are, just associated with the Republican and Democratic Party. Often the Republican Party has really spent a ton of money on these races because of gerrymandering. They know that, state Supreme Courts are kind of the next front in the war over maps and congressional control via gerrymandering, and they've spent a lot of money and they've won.
Yeah, a lot of outside money. Before 2013, we had public funding of these races, so there wasn't this outside money, this big spending. Republicans changed that, also made the races partisan again. I think we're going to leave it there. If you like politics, check out The Wrap at NC Capitol. That's our politics podcast. Once a week, sometimes more often, we'll get you caught up on everything you need to know about state government here in North Carolina. I'm usually on it. It's particularly important right now with the North Carolina General Assembly in session. Search NC Capitol Wrap on your podcast app. Subscribe, leave us a nice little review, and thank you for your attention.